Okay.
The way I got into this, as I was saying before, is that I knew nothing about education. I knew nothing about special education law. Hi.
Yes.
Which one? Education. Or class.
Yeah,
What
education
class?
law and advocacy.
What kind of advocacy?
Mostly special ed, but it depends on the audience.
Okay. Alrighty, I'm just searching.
Okay, have a seat.
Thank you. Well, let me go over to this one too.
Okay.
Okay, thanks.
So, anyway, I knew nothing about any of these things. And so, when my kids started having trouble in school, I pushed back on this and that, and I asked for this and that. But I was afraid of him getting into special education because I knew instinctively that that could be a way to make trouble for him. So I didn't know what to do. But I did figure he needed an IEP, and I said so. But I didn't put it in writing because I didn't know anything about that. And so they contrived to have some people come to my house and say, oh, well, we want to do a mental health evaluation on him. I said, okay. And so they sent a school nurse and they sent a school psychologist who sat there, drank my coffee, and passed the time of day with me. While the school nurse, who knew nothing about anything, asked my son about how suicidal he was. He said, I'm not suicidal, I'm having a good day. I'm not in school. So they went off and said that he was suicidal and called the cops, who arrived 20 minutes later and hauled him away. And they held him in the mental health place for 3 days. And he kept pushing back, and they finally had to vomit him after 70 hours. And after that, he figured he knew all he needed to know about the school district, and he could never go back to school. So all of this, and what came out of all of this, made me learn a good deal about special education law and also advocacy, what you got to do. As far as advocacy is concerned, first off, there's some general principles. It doesn't matter if it's education or anything else. You want to think about, if it's dumb for them to do, it's dumb for us to do. Now, if they call us names or be real snotty to us and we catch them on a tape, we're going to know right away that we got them in a bad place. So that tells us that we shouldn't do that either. So the first thing is we want to be polite, we want to treat them as nice as possible. We want to be considerate. We want to remember, however they may have treated us, that they are made in God's image and likeness, and we need to treat them the way we ought to be treated. That's not only because it's the right thing to do, it's because it's real stupid to do anything else. So the number one thing really is to be polite, and considerate, and to treat them nice. And we may push back, we may throw them against the wall, but we have to be very nice about it. I guess the second thing is important principle of negotiation of any kind. And of course, what I've said applies to certainly how to deal with the police and everything else. Another thing that's very important in negotiation is that in any negotiation, you want to give stuff that doesn't really mean anything in exchange for getting stuff that does. Now, when people get to be 2 years old, they figure out that saying, "I hate you, Mommy," is going to be an effective pushback. Because in order to get what the 2-year-old wants, in order to stop being hated, Mommy's going to have to give the 2-year-old what the 2-year-old wants. So Mommy gets to feel better because the 2-year-old's not saying, "I hate you," but the 2-year-old gets the meat and potatoes that the 2-year-old's looking for, and Mommy really walks away with nothing. So people figure that out when they're about 2 years old, and it works so good that they keep right on doing it when they're 62, sitting across from you at the table. So that means that just the way Mommy, if she's going to get it done, just has to suck it up when she hears, "Mommy, I hate you." When we're dealing with the school district or anybody else, we give them as little real reason to hate them as possible, and then we realize that they're going to hate us anyway. Not because they got any reason to, or because they feel that way, or any of those type of things, but simply because by hating us, they're saying, "Mommy, I hate you," and this way they'll get concessions at you. So you just make up your mind that you're not there to make them like you, or to feel good about you, or to praise you, or to thank you for being such a nice parent, or any of that stuff. You're there to get what your kid needs. And if you, in fact, get what your kid needs, they're going to find ways along the line to show you what a bad person you are. That's just part of the deal. So you let them tell you what a bad person you are, make you feel guilty and everything else, water off a duck, be as nice as possible, and you don't forget what you're there for. Anyway, going down to more details, the law is very complicated in special education. It's a funny thing. I'm not a lawyer, but I can practice education law, and I can act like a lawyer. I can file motions, I can put in complaints and all, I can file briefs and oppositions and everything else. In every way, I can act like a lawyer in one of the most complicated areas of law that there is. I mean, I can't go and represent somebody on rolling a stop sign or anything like that, but I can represent you in any administrative forum, you know, over your kid. Anyway, it's funny how that works, but it's true. So it is very complicated, and there are several laws that all go together and need to be worked out together. One of them, which people forget, is Section 504, and it is a civil rights law. It's very closely related to the Civil Rights Act of 1964. The definition of retaliation and so forth is basically the same one that's used there. It comes from there. And it's a straightforward, you got a right to access type of thing. It's usually used to deal with situations where the kid has diabetes, so he needs to have his diabetes handled so he can go to school safely. Or the kid doesn't hear, so he needs accommodation so that he can hear. Or the kid has some kind of learning disability that makes it hard for things to register, so he needs more time on testing, which in fact is my wife's situation. She's a very bright girl, but she needs more time because it takes a while for things to sink in. They sink in, but they take a while. So it's usually used for that. And the districts will tell you that that's all it's good for. Sometimes the districts will even believe that. But it's not true. It applies first off to discrimination and secondly to retaliation. If they don't teach your kid to read because he has disabilities, then they're denying him access to the high school curriculum or to the junior high school curriculum or whatever. Because, you know, if you read at a second grade level, you might as well be in a wheelchair with no ramp for all the chance you get of actually getting into the curriculum. They screwed you out of what you're entitled to by discriminating against you on account of your disability. They can't be bothered teaching you how to read. That's a Section 504 issue if it's due to a learning disability, and you can be pursued that way. Another statute very closely related to Section 504 is the Americans with Disabilities Act of 1990, Title II, which applies to government entities, specifically schools. 504 applies to people who get any kind of federal funding, no matter how indirectly. The ADA applies whether you get federal funding or not. So you can use that on any kind of government entity which discriminates against you or retaliates against you. They're retaliating against you if you do something that you have a right to do, what they call a protected activity, such as advocating for your kid, such as arguing, saying he needs this and he needs that, such as saying, no, you can't do that, and explaining why, making a complaint, handing out flyers in front of the school to complain about your situation. All these type of things are protected activities. If they push back by saying, well, you're in litigation, so you can't talk to us anymore, talk to the lawyer, or you can't come in a classroom anymore because, you know, we're having some slap and tickle. All of that kind of stuff is retaliation. They don't know any better sometimes, but it's also retaliation when they say, oh, well, your kid has an IEP, so 504 doesn't apply to him.
What is IEP?
Individualized Educational Program. And that is, that relates to the Individuals with Disabilities Act, which I was going to go to next. Individuals with Disabilities Education Act started out as the Education of All Handicapped Persons Act back in 1975. and it's been noodled around with ever since, but basically it's the funding statute that defines how kids with various disabilities and special needs get an education. Now, the Section 504 regulations specify in general terms that every kid with a disability is entitled to a free, appropriate public education, which in the SPED world is called FAPE. And it defines, for example, that they're supposed to assess properly, that they're supposed to place them in the least restrictive environment, which is to say, not needlessly segregating from his non-disabled peers, that sort of thing. And of course, there's a short procedural safeguard that says how you can get a hearing from the district, and they're also supposed to provide a review procedure. They forget about that sometimes. But the Individuals with Disabilities Education Act is much more detailed. It's not a civil rights statute, really, although it has certain civil rights statute kind of aspects to it, but mostly it's not. And so, if you qualify, and there are 13 different ways to qualify, then they are obliged to come up with the services and aids and so forth needed to enable you to actually get a free and appropriate public education. And what that is all defined in the document called the IEP, the Individual Educational Program. And if it's done right, then that's what you're entitled to. Unlike 504 and the ADA, which just say, look, you're entitled to these things, whether it's a document or not. That's an important difference. And so then lots of fighting arises, and there is a detailed set of procedural safeguards where you can ask for hearings, where you can put in compliance complaints and all the rest in order to see how you get there. The IP team is defined as the parents, somebody from the school who knows what the district is able to provide and has the authority to provide it, a general education teacher, a special education teacher, a couple other folks that are required, as I don't remember them off the bat. Then also other people that either the district or the parent figures ought to be invited to a meeting. And the parents are supposed to be part of the IP team. And if they don't allow you to participate properly, then the IP is not valid, and you can wrestle about that in the due process hearing or whatever. One of the usual ways are they predetermine the IP. They decide going in the door what it's going to be, and they may let you move your mouth, but in the end it's going to be whatever they decided in the first place. Sometimes that's impossible to prove. Once in a while there's stupidness easy to prove. But they do that frequently. If they've done that, they've denied parent participation, and as far as the courts are concerned, if they didn't let the parent participate, it's not valid, and they'll lose. Another thing is if they deny you the chance to see the records that you're entitled to see. You're entitled to your education records, and that's defined pretty broadly. And if they don't cough up the education records, then they've denied you participation. And so, in that case too, it's invalid. And so, basically, when we advocate, first off, we try to get them to see reason. We work with them. Sometimes, of course, you've got to bang the parents' heads against the wall too. But mostly, we see how it is that they've denied your rights, and we try to reason with the district and come up with something that is appropriate. And when they are bad boys and girls, then we contrive different ways to apply pressure on them. Of course, the districts have all kinds of money for litigation, and we hardly ever have any money for litigation. That's the problem. Now, there are some advantages to us. One of them is if you win a hearing or a court action with a district, you are entitled to your fees and costs. So if a special education lawyer takes a case and they win it, then the district is going to have to pay him. And the district is going to have to pay him if they want to settle up along the way, too. So That does help, unfortunately. Under 504, you do get your expert witness fees, so you got to call an expert witness.